All right, we would be. Please be seated. We will as well.
Thank you, Your Honors. I'll continue. I'll try to speed up a little bit. First, two quick points. We're joined by Antonella Giordano in this session. Second, I meant to mention earlier in regard to the authenticity of the interview of the accused by the Attorney General's office, excuse me, that defense witness D16 at T131, page 76, when shown the document, stated, "In its appearance, this document pertains to probes carried out by the prosecution or the Attorney General." So authentically, hadn't seen that document before, but recognized it as that a correct format for what you would expect that type of document. I'll continue now, excuse me, talking a little bit about the defense in this case and the well, the nature of the defense. I'll leave it at that. And we can bring up that slide, please. It's a multi-layered defense, Your Honors. The defense argue, one, on and off this came up, sort of abandoned. Ali Kushayb did not exist. He's some kind of mythical figure that may not have existed. That came up at least on one occasion. It's actually at
Well,
P31.
just stop you there very quickly. My understanding is, and the defence can deal with it, is that was abandoned. I agree. It was right
Yeah.
at the beginning of the case, and then it never.
No, it has
reappeared.
been abandoned, Your Honors.
Yeah.
That's not a dispute. Second, if Ali Kushayb existed, he is not the accused. There is no evidence of another individual named Ali Kushayb fitting the same description that came into the trial. Third, if he was the accused, he did not have a position of authority. Four, if he is the accused and he has a position of authority, he committed no crimes, contradicted by reams of witness evidence of persons who knew him for years. Five, if he was the accused and had a position of authority and committed the crimes, he had no way of knowing that they were unlawful or that he could be punished. Six, if he knew his actions were illegal and that he could be punished, he was under duress. Even though duress has not been pled as a defense, we've heard on and on this could be an offense under the state. The punishment could be capital punishment, etc. And then seven, back and forth about an alibi that essentially now it's clear there is no alibi. And Your Honors, forgive me, but it just reminds me of what we used to call the four-dog case defense, which is, first of all, I don't have a dog. Two, if I have a dog, it doesn't bite. Three, if I had a dog and it does bite, it didn't bite you. And four, and if I had a dog and it did bite and it bit you, then it's your fault because you provoked my dog. Essentially what we have here in this trial is an expanded version of that defense. Moving on, briefly, there was no conspiracy, I've talked about this a bit, by the GOS to frame or blame an innocent pharmacist named Abd-Al-Rahman. Defense have argued that at least since 2007, the Bashir regime had been trying to set up their client. And one point I'd like to make there is if that was the case, if the Bashir regime had been falsely leading the prosecution to prosecute their client, why, if he hadn't done anything, if he hadn't been involved in this conflict, and the, quote, real criminals, unquote, al-Bashir, Hussein, and Haroon, had been arrested following the fall of the Bashir regime. Why do they say that the new government, in that transitional period, would have carried on this conspiracy, would have carried on scapegoating their client? And again, it just doesn't make any sense that President Bashir and his government and cronies would randomly pick a nobody pharmacist from Garcilla in order to set up as a Janjaweed leader. And there's nothing in the GOS's behavior from 2007 onwards that would indicate they wanted us to prosecute him. And I already discussed how they refused to surrender him and wouldn't let us interview him. And if that had been the intent of the GOS, to set up Mr. Abd-Al-Rahman, as the defense argued, to draw attention away from themselves, it really didn't work very well, did it? Since his name first appeared along with Haroon, who ostensibly would have been one of the persons that we're trying to protect on our warrants, and that we then got 2 warrants for President al-Bashir and 1 for Hussein, the exact people the conspiracy was meant to protect. It's also been argued, I'll do this briefly, that the witnesses from insiders, victims, persons who knew him in different contexts, as I showed on that confidential slide, that they're all part of a conspiracy dating back 20 years. In that point, I would make the point again, Your Honors, as we made in the opening, that throughout this trial, before the trial, following the arrest, nobody has come forward to say, you've got the wrong guy there. That's not Al-Qushayb. Nobody wanting justice has come forward and said, I know Al-Qushayb. He burned down my village. He stole everything I had. He killed members of my family. I want the real Al-Qushayb to face justice. You've got the wrong person. Not a single one has come forward. And for the scope of this conspiracy to work, which I argue continues to this day, it would have to span the government of Sudan, the National Intelligence and Security Service, the Ministry of Defense, the Sudanese Office of the Prosecutor, the National Commission of Inquiry, the UN Commission of Inquiry, Human Rights Watch, Radio de Banga, Facebook, and others. And of course, all the prosecution witnesses from all walks of life. I touched on this before, but at the beginning, in the opening of the trial, the defense made the argument, referring mainly to their witnesses, I won't read it again, that the name Al-Qushayb was not widely known and associated with their client, Riyad Alberti. I won't read it again in full, but my friends made the point that D32 would be the person to know. Listen to D32. And that D32, in common with many other witnesses, in fact, heard the name Al-Qushayb only in connection and at the time of the surrender. As I said, by the end of his testimony, and I'll be careful on what I say in open session, D32 admitted that he had heard the name Al-Qushayb in 2003. 17 years before when the defense told us. And he heard that in the town where he was at the time, which I won't mention. I'll take you, Your Honors, to T141, page 29, starting at line 21, going over to the next page. The people were talking about a man named Al-Qushayb. That's the truth, isn't it? Answer from D32. Yes, that's correct. In the town in 2003 and 4, right? Answer, yes, right, people were talking. I didn't know anything about that, but I've heard that name all the time. All the time he heard the name Al-Qushayb at the time of the crimes. And even more revealingly, the witness was asked a question by Your Honors towards the end of his testimony. And Your Honor, Judge Alapini Gansu, asked D32 a very relevant question. Your Honor asked D32, who knew the accused Abd-Al-Rahman well, why he never asked the accused, why did you never ask the accused why people called him Al-Kushaib? The witness's answer, it wouldn't be proper for me to do so. At first he said, I was too young. Later, Your Honor put to him, well, 2013, you weren't a child. Why didn't you ask him then? Why didn't you ask Abd-Al-Rahman, who you knew, why people call him Al-Kushaib? And he said, I just couldn't. I just couldn't. The answer was not, what are you talking about? Why would I ask him that? I'd never heard him called that. The answer was not because he never had that nickname. The answer was, I just couldn't do it. I'll skip that, Your Honors. As I've said, I was going to give some examples, but please check the brief carefully, the cites. Moving on now, Your Honors, I'm going to talk a little bit about the fairness of the trial. And I'll start very quickly with the visa issues, which we've heard about and was hammered by the defense during this trial. Throughout the trial, in its final brief, and I expect to continue in this courtroom in the next couple days, the defense has relentlessly complained about supposed unfairness. One example, defense constantly complaining about not being able to go on mission to Sudan because of visa issues. And, Your Honors, I say these are a typical and good example of defense efforts, frankly, to create an illusion of unfairness or undue prejudice. First, when the visas were ready at the Sudanese embassy in Sudan, I won't go through it all, they didn't pick them up. They didn't pick them up when they heard they were ready. Second, they received 6-month multi-entry visas in June 22, but they only went on one mission during those 6 months. And those visas had a 30-day limit on them, meaning that each stay during the 6-month period could not exceed 30 days. But what it does mean is that for the 6 months from June 22 on, before there was any unfortunate high-level armed conflict, they could have gone to Khartoum for 6 30-day missions. They could have staggered, as the prosecution did, its presence in Khartoum to have a semi-permanent effect. They could have gone on 12 2-week missions if they wanted, but they could have gone over and over and over again during that period, yet they only went once. And they met witness D1 there when they went. And he confirmed that the correctness of what I'm saying. This is at T154, page 80, lines 11 to 17. So my question, and I'm not criticizing you in any way, is that when you met the defense, did they tell you that they had 6-month multi-entry visas for Sudan? Did they tell you that in June? Answer, yes, they told me. Question, okay, so you could have met them in July, August, September, October, or November 2022 in Khartoum, correct? Yes, is the answer. Now look at how they describe their ability to visit Khartoum in the final trial brief. Paragraph 49. The defense received its only visas to enter Sudan, allowing it to go once on mission to Khartoum, only in June 2022. Paragraph 61. The defense was granted visas for only one mission in June 22, and to Khartoum only. And that's true, that it was to Khartoum only. This issue of the gross unfairness and the gross damage by not having visas, apparently, and being limited to one mission, was raised 4 times in the opening statement. That's how much weight they've put on this. I won't go through all of them, but the first one is on page 47. Ever since we were designated in June 2020, and despite our constant requests, the defense has received but a single visa valid for 30 days to travel to Sudan. And obviously we rushed in, and we did travel there in June 22. I won't go through them. There's 3 more similar references to the opening. Carefully worded complaints noting the 30 days, but strongly trying to imply there was only one chance to go. We were limited. We went one time, and we could only go one time. We've corrected that misrepresentation before, but I felt like we had to do that again today. And I'll just note on D1, they never got a statement from him. They had 2 screenings. They didn't get a statement from him when they went in June 22. They never went back to see him, and they talked about the difficulty of getting him and getting a statement, which they in fact never got, just 2 screenings. The defense also make much in there, a lot of noise, and a lot of argument in their brief. I won't go through it all. It's in paragraph 65, about how hard it was for their witnesses to travel to the 3rd country where they testified, and how unfair it was, and how it violated equality of arms, and it was such a level of hardship. Your Honor, that's just not true. It was not hard. It was not unfair. It didn't violate anything. Prosecution assisted the defense in getting their witnesses to this place where they could testify from, because we had to go there and prove that it was possible to travel there by public transport, that it could be done in just a few days, that it was reasonably safe, that the government of that 3rd country would issue permits and would cooperate and assist. All of that we had to show and prove was possible, and then the defense got their witnesses there exactly that way in the end. And of course, to the best of my understanding, every defense witness who came on that route returned home safely and was not harmed there or back. And what may have assisted was the fact that in part of the area of control that these witnesses had to travel through, there wasn't fiery active combat at the time, although there was in other parts of Darfur and Sudan. And the commander of that region was from the accused tribe. One of the really sort of bizarre claims in the brief and in the trial that I just want to address quickly is that the prosecution met with a man named Ali Kushaib in Khartoum in June 2006. I don't quite understand what the allegation is, but that we interviewed him or tried to interview him and met with him. This is at the defense brief 68 to 72. And we are accused of this grotesque disclosure violation for not disclosing the transcript, the notes of a meeting with Ali Kushaib, who we met in Khartoum in June 2006. Your Honor, this meeting never happened. Prosecution never met with the accused in Khartoum or any other phantom Ali Kushaib. There was and is nothing to disclose about the meeting, which never happened. The defense were informed that there was no meeting and nothing to disclose. The correspondence I referred to earlier, the letters from the GOS, showed that they refused to allow us to meet with the accused. And the one witness the defense rely on for this entire saga, D16, testified that he did not know if this supposed meeting happened or not. It's a T-132, Your Honors, page 21, and then it comes up different places. So this meeting never happened. Made it clear to the defense that this meeting never happened. We have never met and interviewed or spoken to Ali Kushayb in Khartoum. How does the defense, in their brief, impact the fairness of this disclosure violation? Paragraph 72. The occurrence of that meeting, or tentative meeting, provides strong evidence that the man called Ali Kushayb, who was at least due to meet with the OTP, was not Mr. Abd-Al-Rahman. This evidence is not only proof of an irreparable breach of fairness of the proceedings by the OTP for not having kept and disclosed a record of that event, it creates extensive doubt surrounding the OTP's allegation that Mr. Abd-Al-Rahman is Ali Kushayb. It's just astounding, Your Honors. Very quickly, I don't mean this, I'm sure this is an inadvertent error, but the defense do on occasion cite to materials in their brief that are actually not in evidence, not in the record. A few times. We have made that mistake, possibly, I hope not. They cite to 2 press releases from the ICC website. That's in paras 99, 102, and 696 of their brief, which are not in evidence. They cite to investigation notes that are not in evidence. It's at paragraph 53, footnote 114. 2 investigative reports, I believe. And they cite to witness statements of a viva voce witness. So witness statement was not a witness where the statement came in on paper, but they cite to the statement. Nevertheless, that's witness 1073, paragraph 738, footnote 2774. Your Honors, this trial throughout was fair. You ensured it was scrupulously fair to the accused, and this is true despite the best efforts of the defense to paint it otherwise. And I said, I expect there will be more baseless allegations of unfairness coming in the next couple days. If you look at the record, the defense was able to put on a solid case, calling witnesses from Darfur and from outside Sudan. They put their witnesses on. There was no inequality of arms. Your Honors made a number of accommodations and helped the defense to put their case on. First of all, I won't be specific, but there was some pretty innovative AVL in this case that helped with everybody working together to get their witnesses able to testify on 2 occasions. Your Honors granted the defense 2 postponements and 1 delay of the resumption of the case. Point is, they were given plenty of time to prepare. Plenty of time to investigate, prepare, put on their case, and they did. Yet, this is how the Chamber characterizes Your Honors' measures to ensure a fair trial. Throughout, this is, defense paragraph 680, defense brief paragraph 689. Throughout the proceedings, the defense suggested creative remedies and sought the intervention of the relevant chambers to take measures within their jurisdiction and powers to compel Sudan to cooperate. All solutions proposed by the defense were ignored or denied by the chamber. Your Honors, the only unfairness in this trial is the way you've been described by the defense. Prosecution had its last witness on 15 February 22, formally closed its case at the end of the month. Defense case did not start until over a year and a half later. Didn't formally close its case until September 24. Creative remedies they're talking about. The one creative remedy, the most obvious one, that they chose not to follow was go to Sudan. Go to Khartoum when you have 6 months to investigate. They make a lot of points about how they couldn't go to Darfur. OTP's never been able to go to Darfur to investigate. There have been a couple visits by the prosecutors but not investigative. We have never been able to do that. What we did is when we were able to go to Khartoum during that window, we brought witnesses from Darfur, as the defense did with D1 and one other witness at least, to meet with us, and we took statements. They could have done that. They chose not to. And I'll skip ahead a bit. Your Honors, I won't even show this slide. This is a confidential decision, but I'd urge you, everything you need to know about the allegations of unfairness in this case, it's a confidential decision. But if you look at decision 1097, the Appeals Chamber decision of March 24, look at paragraphs 55 and 56. This should not be broadcast. That tells you all you need to know, Your Honors. Unfortunately, I can't read it out. I won't go through it, but Your Honors, of course, have found that the delays in the preparation and investigation of the defense case were at least partially attributable to the defense. And that's in your postponement decision 916, paragraph 39. I won't read it out. Talk a little bit about the failure of the GOS to answer defense RFAs, and I believe this was a question, but I'm coming to question 10. Sorry, Your Honors. GOS didn't supply the defense with all the documents it requested. That did not render the trial unfair. And the argument that these documents would have assisted the defense is truly raw speculation. The GOS did send a response on 22nd October of this year, indicating that some of the files were inaccessible due to the current conflict. They provided some materials about courses and curricula and training in IHL. I won't describe it further. I think it's technically still confidential, although there's should not be, probably. And the defense acknowledges in their brief at paragraph 50. But this partial non-cooperation of Sudan, and I am not defending the GOS's not responding to some RFAs, does not make the trial unfair. And as your chamber has decided and made clear and said more than once, cooperation is often not to be expected in trials before an international court like this one. And Your Honors said this at decision 990, paragraph 12. Given the nature of this court, neither an ongoing conflict nor a lack of state cooperation are exceptional in nature and should not be insurmountable, nor lead to impunity, nor pretend achieving justice for their victims. So coming to question 10, regarding Sudan's failure to provide certain records requested by the accused. And I understand that we didn't object. The defense just received a response on some relating to criminal records. But the defense makes absolutely speculative claims that these documents would, quote, definitively establish that Abd-Al-Rahman is not Ali Kushaib. They say these were the utmost importance to the case, and then again, the trial cannot be fair because we didn't get everything we asked for. There is no reason to believe that all civil registration documents, that all of these documents would include the nickname of the individual or other individuals, or that the absence of the nickname on such a document was proof that the person did not contain a nickname. And many of these documents, given the ability to keep records, the length of time going back to 2003 and 4, they may not even exist. They might have been unobtainable even with the best will in the world. And as I said in the beginning or earlier, there is no alibi defense in this case. This is something that the documents were purportedly going to be decisive on. But their own witness I'll just cite the, rather than quote, I'll cite it. The DAR D31, 274, at pages 5 to 6, paragraphs 20, 22, and 23. Their own witness confirms that he wouldn't have been in El Obeid, in joining the RSF at the time of the Delege incidents. And frankly, you look at some of the documents I've shown you today from the government of Sudan, some of the ones that were referred to in your question, A, B, C, D, and E. Defense is probably fortunate that more official documents about their client weren't provided. Conclusion, there was no actual harm, there was no undue prejudice ever identified for lack of cooperation. There was none, which is why it has been impossible for them to establish it. They were afforded, by your honors, a scrupulously fair trial. You worked hard to make it so, all the way throughout. Coming to the end, your honors, all this raises the question, why did the defense complain incessantly, in this case, about unfairness when there wasn't any? Why did they continuously manufacture this appearance of unfairness or prejudice where there wasn't any? The answer to that question is clear. It's an effort to avoid this case being tried and decided on the merits, on the facts, on the evidence. It's the unspoken recognition that their defense doesn't fly, and that based on the evidence, their defense will fail. I don't like saying this, your honors, but from the beginning, that strategy, creating a record of non-existent prejudice, unfairness, is aimed at the appeals chamber. And all you need to know that that is correct is to look at their opening statement. I've put it on the slide. It's the opening statement. This is before they've called their first witness. They're addressing your honors. So faced with this simple and true presentation of this sad reality, this comparison between, on the one hand, the time and facilities and the means given to the office of the prosecutor with, on the other hand, the blame reserved for the defense, the inflexibility in granting it the little time it has requested to continue its investigations. Would that situation stand up for a single second to an examination of the fairness of this trial by a reasonable observer? The answer is clearly no. In this case, the fairness of the trial has been definitively ruined by all, or tarnished by all the reasons that I have mentioned. The chamber will, of course, your honors, the chamber will, of course, not be in agreement with my analysis, and it is up to another chamber to note this obvious fact hereafter. It's a question of patience. The evidence cannot always be denied. It is too obvious, it will come. That is their strategy, complaining that the trial was definitively ruined before they even called their first witness. Your honors, based on everything I've gone through today and everything you've heard throughout this trial, the accused, Mr. Abd-Al-Rahman, is Ali Kushayb, the Ali Kushayb who committed these crimes. The evidence is overwhelming. It's beyond reasonable doubt. He's guilty, each and every one of these charged crimes. I'm done. I'll turn it over to Mr. Jeremy.
Thank you, Mr. Nichols. Yes, Mr. Jeremy.
Thank you, Madam President, Your Honours. Your Honours, I expect to address you over approximately 1 hour and 15 minutes, and I'll address 4 topics. I will speak about the Janjaweed militia, Abd-Al-Rahman's position of authority and influence, issues relating to jurisdiction, and also the Kadum and Bindisi attack. Your Honours, first I'll deal then with the Janjaweed militia, and these submissions are partly responsive to your question number 12. I'll look at what the Janjaweed were, why the government of Sudan used them, and how they interacted with government of Sudan forces. Your Honours will have noted that the term Janjaweed is defined in paragraph 80 of our final brief. And in so doing, we rely in part on the testimony of joint expert P1042, Alex Duval. And on the screen before you, you will see his definitions of Janjaweed, including a term used to refer generically to pro-government militia in 2003 to 5, forces mobilized on an ad hoc basis, different Arab clans forming brigades known as Janjaweed. And Your Honours will also recall that Professor Dawal noted that the government of Sudan and a number of Arab tribes in Darfur at the time preferred to say that the Janjaweed are common criminals, that they are nothing to do with the Arab militia. And you'll recall that notably Abd-Al-Rahman himself took this very position in the interview that he provided to the government of Sudan that Mr. Nichols has mentioned in his submissions. We see here that he states, of course we are not the Janjaweed. The Janjaweed are people that engage in plunder and are bandits. We are the Furzan, who fight against those who attack the state and in accordance with the directions from the state itself. Now, Your Honours will note here Abd-Al-Rahman's use of the word Furzan. And as we set out in our final brief, for example, paragraphs 80, 130, 131, multiple witnesses confirmed that this term Furzan was one of the various ways of referring to the Janjaweed militia. For example, P547 described the accused as a Furzan commander, a position which he described as a, quote, field role in order to end the conflict in Darfur. This obviously meant military operations, killing, rape, burning down villages, end quote. And that's in paragraph 131 of our final brief. P883 and 1021 also described Abd-Al-Rahman as the leader of the Furzan, which they both confirmed was another word for Janjaweed. And documentary evidence, including from the government of Sudan, also referred to Abd-Al-Rahman in the same terms. And I'll give one example from the National Commission of Inquiry report that stated, in reference to the executions in Delej, quote, the detainees were taken to the Delej police area by the leader of the Furzan armed militia, Mohammed Ali Kushaib. Just one moment, Your Honours, my live note has gone down. Your Honours, I'll turn now to the question of why the government of Sudan needed to mobilize the Janjaweed to fight the counter-insurgency. In their brief, paragraph 313, the defense state that the prosecution do not provide, quote, any beginning of explanation as to how and why non-military, non-police, normal citizens of Sudan would suddenly get mobilized, equipped, trained, paid, and structured to undertake the perilous task of fighting against a well-armed, well-structured, and powerful rebellion. To the contrary, Your Honours, this explanation for why the Janjaweed were used is set out clearly in our final brief, paragraphs 100 to 103. And briefly, Your Honours will recall the evidence in this case in relation to plans issued in relation to Darfur, the Darfur conflict in 2003 by the National Security Council. You'll recall that that was a body that set out the policy for the counterinsurgency campaign in Darfur. And you recall that those plans, firstly the emergency plan issued shortly after the attack on Al Fasher Airport in April 2003, and the annual plan issued on the 18th of December 2003, made clear that the members of the SAF, the Sudanese Armed Forces, and the Popular Defense Forces could not be trusted to participate in the counterinsurgency because the majority were from Darfur and the government feared that they would defect to the rebel forces. And again, it is notable, Your Honours, and I highlight it now, that this issue of distrust among firm members of the government of Sudan forces is also something that Abd-Al-Rahman referred to in his interview with the government of Sudan, where he noted, for example, as we see on the slide before us, at the time the rebellion started, most of the police were fur. They handed their weapons over to the rebels. They joined the rebellion, and some members of the army also joined. And you recall, Your Honours, from the testimony that we refer to in paragraphs 101 to 103 of our final brief, from, for example, P547, P769, they testified that pursuant to these plans, the government of Sudan took the decision to recruit Arab militias to fill this gap in manpower to fight against the rebels in the counterinsurgency. And Your Honours will also recall, again, the joint expert, Professor Dawal, confirmed that this recruitment of irregular forces in this way was entirely consistent with the way that the government fought and had fought counterinsurgencies in Darfur for the last 20 years. As we set out in our footnote 387, he also noted that the mobilization of such forces since the 1980s regularly resulted in widespread and indiscriminate attacks on entire communities, forced displacements, rape, and indiscriminate killings of civilians. And you recall that he used a particular phrase, a particular way of explaining this use of irregular forces. He used the term counterinsurgency on the cheap. He explained it was cheap because in the short term, the budgetary burden was light on the government because the Janjaweed, as de facto forces, received little or no pay. However, he did note the longer-term cost of this policy, stating, quote, "The bill, of course, became due later on, and the human cost is here before this court," end quote. Lastly, on this issue, Your Honours, you'll confirm that various witnesses confirmed the coordination role played by, in particular, former Minister of the Interior Abd-Al-Rahman Hussein, and State Minister for the Interior Ahmed Haroun, in coordinating the various forces of the counterinsurgency. And you recall that, as we set out in our final brief, for example, paragraphs 160 to 170, there's substantial evidence about the close coordination between the accused and these men, in particular, Ahmed Haroun. Your Honours, I now want to move to the relationship between the Janjaweed and the Government of Sudan forces. I'll discuss this in general terms, but the more specific relationships in relation to the charged incidents will be discussed throughout the presentations in the prosecution's closing. You see on the slide before you, we've set out on the left side the various formal forces within the Government of Sudan's counterinsurgency effort, and on the right side, the militia Janjaweed. Now, Your Honours, the evidence demonstrates, and I will come to this, that during the charge period in 2003 and 4, Abd-Al-Rahman Ali Kushaib was in command of these forces on the right side, the militia Janjaweed forces, in the Wadi Salah and Mukjar localities. We note here that they're known by various names, and we provide additional names in the brief. I've mentioned the name Furzan. Multiple witnesses said that this meant the same thing as Janjaweed. They were also known as Mujahideen, and witnesses such as P954 stated that this was another term for Janjaweed. The reference for that, Your Honours, is DAR OTP 0221 0571, paras 20 and 27. Your Honours, as we set out in our brief, paragraphs 81 to 83, and throughout the brief in relation to charged incidents, the evidence proves that Abd-Al-Rahman's forces existed independently of these other forces, but coordinated closely with them. As examples of this coordination, the government would provide money and weapons, and they would also conduct joint operations together, and we refer to various of those operations in our brief and in the context of the charged incidents. Again, turning to the joint expert, he, as well as various other witnesses, made clear that the belligerent forces in this conflict in Darfur were not static, well-formed, well-structured groups. Instead, he explained that their organization was ad hoc, it was circumstantial. He explained that the lines of authority depended on what was happening in a particular time and in a particular place. And as a consequence, Your Honours, the evidence demonstrates that there was no standard model, no one-size-fits-all model for how the militia Janjaweed were organized or how it coordinated with the Government of Sudan forces. It depended on the events on the ground in a given time and place. And in this case, Your Honours, there is ample evidence of how those events transpired on the ground. In particular, how Abd-Al-Rahman commanded his militia Janjaweed and how he interacted with those other forces, including during the commission of the charged crimes. And that evidence, Your Honours, which we will emphasise during this closing, consistently demonstrates that notwithstanding this ad hoc coordination with the Government of Sudan forces, Abd-Al-Rahman remained the most senior Janjaweed militia commander in the Wadi Salah and Mukjar localities, and that during operations, joint operations with Government of Sudan forces, he maintained his command over his men throughout. As regards his relationship with the PDF, the evidence shows, as set out in paragraph 78 of our final brief, that the PDF was one of those forces that coordinated closely with the militia Janjaweed. often to the extent that, in practice, de facto, many considered them to be the same forces. Your Honours will recall that there is a significant body of evidence in this case that, as well as being referred to as a Ferzan commander and an Agid al-Oghada, and I'll come to that particular term, that Mr. Abd-Al-Rahman, the accused, was also known as an emir. Now, P547, as Your Honours will recall from paragraph 131 of our final brief, described that term as a wartime commander, and the evidence demonstrates that this term, emir, like Agid al-Oghada, was simply another term to denote leadership of the Janjaweed militia. And witness evidence, again including from our joint experts, confirmed that leaders during the conflict sometimes used the term emir, other times they used the term Agid al-Oghada, and sometimes they would use both. And that reference is transcript page 28, T28, page 44. And again, Your Honours, I'll bookend this point by referring to Abd-Al-Rahman's Government of Sudan interview, where he referred to himself as the emir of the Ferzan. Ferzan, of course, as I have explained, was simply another word for the Janjaweed. So given this close coordination, Your Honours, between the PDF and the Janjaweed, and that close de facto relationship, many witnesses used the term interchangeably, and we expressly recognise this in our final brief, paragraph 82, and the defence brief, as you'll have seen, devotes a considerable amount of space to this issue, paragraphs 323 to 333, for example. However, despite this occasional blurred distinction in labelling, the evidence overwhelmingly demonstrates that Abd-Al-Rahman's militia Janjaweed in the Wadi Salah localities during 2003 and 4 were not de jure parts of any Government of Sudan force, including the PDF. Indeed, as we heard from P1042, a feature of the counter-insurgency operation is that these militia forces were not formally part of the government's army or the police. That's why they were required. And the evidence further demonstrates that this de facto coordination between the government and the Janjaweed had no impact, no dilution on Abd-Al-Rahman's command role. Indeed, the evidence, Your Honours, demonstrates the opposite. I'll give one example of that. Your Honours will recall P905's evidence, and he gave evidence about the Sindhu operation, and we've included some excerpts on the screen before you. He explained that this operation involved a convoy comprised of 33 soldiers, 13 PDF, and thousands of Janjaweed. So we see he drew a clear distinction between the SAF, the PDF, and Janjaweed commanded by the accused. He explains that the commander of the convoy was a major, but the leader of the Janjaweed present during the operation was the accused. And Your Honours will also recall on this issue the evidence from P1021. I won't give his position, but you will recall he is someone very well placed to give a view on this issue. He readily accepted that there was an agreement between the government and the Janjaweed. It's not something he shied away from, but he forcefully rejected the suggestion when put to him that the Janjaweed and the PDF were essentially the same. And that's T81, pages 58 to 9. And again, Your Honours, to close this point, I'll refer to Abd-Al-Rahman's Government of Sudan interview, where he too drew a clear distinction between the PDF and the Ferzan, stating, quote, "During our conflict with the Fur, we were, of course, a mix of People's Defence and Ferzan." Now, Your Honours, we do acknowledge in paragraph 81 of our final brief that the militia Janjaweed were eventually recruited into the GOS forces on a de jure basis. But the evidence demonstrates that this happened after the charged events. In the accused case, as we set out in paragraph 81, he completed his evolution from Janjaweed leader to a de jure member of a GOS force in 2005 when he joined the CRF. And similarly, one of his Aguids who I mentioned, Bonjus, he joined the border guards at a similar time, and we make that point in paragraph 44 of our final brief. Your Honours, I move now to the second of my four topics, Abd-Al-Rahman's position of authority and influence during the charged crimes. I'll focus on his evolution from a member of the SAF to a Janjaweed militia leader during the charged period in 2003 and 2004. Now, Your Honours will have seen that in their brief, the defence take the position that, for example, in paragraph 61, quote, "Mr. Abd-Al-Rahman has never been in a position of authority over the Janjaweed militias," end quote. Paragraph 3 of their brief, they state, quote, "He earned an honest and modest living by selling medicines in a shop. His life was that of a humble Sudanese citizen," end quote. Your Honours, the prosecution's final brief tracks Abd-Al-Rahman's rise to his position of authority and influence, and we do that in paragraphs 127 to 200. I want now to briefly look at a timeline of that evolving experience and authority. Although not citing to any evidence, the defence suggests in their brief that Abd-Al-Rahman joined the SAF in around 1964, when he was approximately 15 years old. At paragraph 300 of their brief, the defence say that, quote, "Mr. Abd-Al-Rahman has never been an Aguid," end quote. Your Honours, this is directly contradicted by defence witness D28. D28 said that the accused Abd-Al-Rahman was an Aguid when he was a child, when D28 was a child in around the 1980s. And we make that point in paragraph 68 of our brief. And you'll recall that an Aguid, Your Honours, was a tribal military leader. P883 corroborates to an extent D28's evidence that Abd-Al-Rahman was an Aguid of the Taisha tribe during the 1980s by confirming that he was, quote, "a prominent person in fighting the Salamat tribe," end quote, on behalf of the Taisha tribe in the 1980s. That's T74, page 4. And notably, the defence relies on this evidence from P883 in paragraph 148 of its brief. Moving to Abd-Al-Rahman's active service in the military, the defence asserts in their final brief that Abd-Al-Rahman never deployed on a combat operation and never had a command role. That's paragraphs, for example, 3 and 789 of their brief. To the contrary, Your Honours, various witnesses in this case, as you will recall, testified about Abd-Al-Rahman's prior military experience. For example, P883 stated that Abd-Al-Rahman was in command of forces in the conflict in South Sudan. He explained that, quote, before he got his credentials, he was a military service member, he was a warrior. After he got his credentials, he received a certificate and started doing healthcare work. But originally, he is a military service member. And the evidence from D39 also confirmed that Abd-Al-Rahman was in the SAF for what he said was 6 to 7 years before he moved to a medical field. And we make that point in paragraph 671 of our final brief, Your Honours. Now, in the early to mid-1990s, focusing back on our timeline, Mr. Abd-Al-Rahman retires from the SAF. Based on an excerpt of his interview to the government of Sudan, after retiring, after going to Garcilla, he appears to have continued to be in a command role of armed men in Garcilla and to perform duties remarkably consistent with his previous role as an Agid in Rahad al-Burdi. For example, focusing on the second part of the interview on the screen, he explained, whenever an incident of looting occurred, I would request weapons from the army and the police, but mostly from the army. I would next assemble the available force, usually as a group of 100 or 50. I oversee the group. If the cattle were returned, there would be no armed confrontation. But if they refused, we would fight it out with them. Next in the timeline, Your Honours. Prior to 2003 and 4, the evidence demonstrates that within Garcilla, within the Wadi Salah locality, Abd-Al-Rahman became an Agid al-Ogada, simply the head of the other Agids or colonels, the colonel of colonels. We set out that evidence in paragraph 138 of our brief, and the evidence confirms that this appointment, this position, was based on his prior military experience and his experience of warfare. Your Honours heard evidence that in Garcilla, the leaders of the different Arab tribes that were present there, they came together and they agreed to appoint Abd-Al-Rahman, even though his tribe was far away. And I've put that excerpt on the screen for Your Honours. And I'll emphasise the last line, that all of those leaders agreed to appoint just one person, and they all agreed that that person should be Ali Kushayb. Moving forward, in around early August 2003, Your Honours will recall the evidence that the accused was appointed the head of a Mujahideen committee. And this was a role that required him to equip, prepare, and mobilize men for warfare. We set out that evidence in paragraphs 140, 172, and 173 of our brief. Witness P643 explained that this appointment was based on, 1, his military experience, 2, the fact that as Agid al-Ogada, he was, quote, well positioned to know all the colonels and their positions and functions, because that was at the heart of what this role was and what his work was. And again, Your Honours, I want to focus your attention on an excerpt of the accused's interview with the government of Sudan, where he appears to explain that he performed this very role. We refer to this in paragraph 174 of our final brief, and in this interview, Abd-Al-Rahman refers to assembling his force, distributing weapons to his Agids, addressing the Security Committee in Garcilla in relation to the distribution of weapons. All functions that echo the evidence in relation to his role within this Mujahideen committee. The next major event in the timeline of the evolution of the accused's authority, Your Honours, is the rebel attack on Mukjar. Evidence about this is set out in our final brief, throughout the brief, particularly paragraph 141. But, Your Honours, the main point to emphasise here is the following. In late July and August 2003, following an attack by rebels on Mukjar, Abd-Al-Rahman and his Janjaweed militia entered Mukjar, and in so doing, they were credited with preventing the rebel forces taking over Mukjar. In this way, Your Honours, the accused demonstrated his value to the government of Sudan, to Haroun and senior members of the government of Sudan's forces who had travelled to Mukjar shortly after the attack and met the accused. Earlier, Your Honours will recall that I spoke about the resource gap that the government of Sudan was experiencing at the start of this counter-insurgency. Your Honours will recall the evidence from Professor Dewal that the lines of authority depended on what was happening in a particular time, in a particular place, and who could provide what was needed for the conduct of operations, be it ammunition or armed men. And in providing security to the government of Sudan forces in Mukjar, the accused demonstrated that he could fill that resource gap, that he had command over the militia Janjaweed who could fight with the government in the counterinsurgency, in that particular time, in that particular place. And this is exactly what the government of Sudan needed. And as a consequence, Your Honours heard the evidence that senior figures in the government of Sudan, including Ahmed Haroun, endorsed Abd-Al-Rahman, offered him money and weapons for his men. And again, Your Honours, it is notable, and I emphasise, that in his government of Sudan interview, the accused, as we see on the excerpt on the screen before us, refers to receiving money and weapons from Haroun and the PDF coordinator. And you'll note in particular that he states, quote, at the end of the penultimate sentence of the first paragraph of text, they agreed that the weapons would be for my force. As we set out in our final brief, Your Honours, in particular section E, after the accused had demonstrated his value to the government of Sudan in this way, he began to cooperate and coordinate not just with Haroun, but with other senior political and military officials. These relationships are reflected in Annex 6 of our final brief, which is partly reproduced on the slide before you. I won't go through all of those relationships, but I will again note that in his government of Sudan interview, Abd-Al-Rahman expressly refers to his relationship with many of these individuals, including Haroun, Army Commander Bakit, Lieutenant Hamdi, PDF Commander Al-Harika, PDF coordinators Hazabala, and GOS locality commissioners Abd-Al-Hakam and CRF Commander Hamadan. So following these events, Your Honours, the evidence clearly demonstrates that at this point, Abd-Al-Rahman is the senior militia Janjaweed leader in the Wadi Salah and Mukjar localities, the only leader with these relationships that I have just outlined. And he was tasked by the government to lead armed men to fight the counterinsurgency. And here I want to pause and remind Your Honours of the profile of a typical Janjaweed militia leader, the P547 provided. And it's on the screen before us. And I've highlighted the relevant parts. He emphasized, quote, "The main relevance in this is how the person can conduct the mission given to him by the Sudanese government. And this is how they used to use the Arab tribes for military purposes against African tribes," end quote. He went on to say, quote, "What matters is for him to be an Arab person from Darfur and that he is capable of performing an activity or something that could help the government of Sudan in countering the rebellion," end quote. Now, Your Honours, here P547 is giving the profile of a Janjaweed leader in a general sense. He's not referring specifically to Abd-Al-Rahman, but you will note, Your Honours, that the profile describes the accused exactly. Moving to the general structure of the militia Janjaweed in the Wadi Salah and Mukjar localities in 2003 and 2004, we set that out in basic terms on the slide before you. At the top, we see that the accused was the senior militia Janjaweed leader, also known as Abd al-Ogada, as I mentioned, also known by other terms, including Emir. And the prosecution case, and this is demonstrated by the evidence, is that as the senior leader, the accused had authority over the Agids operating in this region, as well as the men subordinated to those Agids. And notably, again, referring to the accused's interview with the government of Sudan, he estimated that his force was made up of 2,500 men. And the reference there is DAR OTP 0219 7007 at 7011. Now, Your Honours, as you've heard, as I've mentioned, the defence, of course, take the position that at this time, August 2003, their client, the accused, is a simple pharmacist in Garcilla, and they say that he couldn't have been a senior militia Janjaweed leader or the Abd al-Ogada. And they say that this was for a number of reasons. And I'll touch on some of those. They suggest, Your Honours, in paragraph 288, the defence suggests, that the authority of an Abd al-Ogada was limited to Agibs of the same tribe. And in making that assertion, they rely in part on Professor Duval, among others. In fact, Professor Duval said the opposite during his testimony, Your Honours. He said that when irregular militia were being formed at the time of the counterinsurgency, whenever possible, the government would simply enlist, quote, people who had prior military experience to organise and lead their forces, end quote. He was then asked, well, what about the tribe of that leader? And he said, quote, it would not matter, end quote. That's P1042, transcript page 29, page 22. Another argument that the defence asserts as the reason for why their client could not be the foremost Arab militia leader during the charge period is that this couldn't have been possible because the Taisha tribe were not officially involved in the counter-insurgency. And therefore, Abd-Al-Rahman, as a member of that tribe, couldn't have been involved. They make those arguments in paragraphs 770 to 773. And in making those arguments, they again rely in part on the joint expert, Professor Dawal. They say that he purportedly confirms that there would be significant consequences for an individual who went against the wishes of a tribal leader, as well as his family, in terms of social standing and esteem within the community. Again, Your Honours, that's not what Professor Dawal said. What he said is that while consequences for social standing and esteem within the community could be significant, there would be few material consequences. Asked if there would be consequences for a person's family, he simply said, "I imagine so." And he went on to say, and I'll put this on the screen before you, no I won't, but I'll quote it. He went on to say, "In most cases, and especially if an individual were outside the immediate domain of the tribal chief, the individual could challenge the tribal authority with very little recourse." And he went on to say, "So with the growth of towns, people residing in the towns and cities felt that they did not really feel the ties of allegiance to tribal authorities." And that's T28, page 72. And Your Honours will recall the evidence in this case that Garcilla was a major town in the West Darfur state. On this same issue, Your Honours, the joint expert also stated that the government of Sudan would mobilize militia regardless of the position taken by the tribal chief. He stated, quote, that the government could simply go around the tribal chief. That's T28, page 71. The next reason why Abd-Al-Rahman couldn't have been a tribal leader, why he couldn't have led the Janjaweed forces in the counterinsurgency that the defense asserts, is because the Janjaweed militias in Wadi Salah and Mukjar were, quote, predominantly Salamat. That's paragraph 336 of the defense brief. They say the Janjaweed were predominantly Salamat. And here the argument goes that because the accused was fighting the Salamat 20 years earlier, you recall 883's evidence about this, you recall D28 says he was in Agid at the time, then in 2003 and 4, he couldn't possibly lead members of the Salamat tribe who constituted the majority of the Janjaweed because they wouldn't follow him because of that conflict. Now, the main flaw in that assertion, Your Honours, is the defence rely on Professor Dawal for asserting that, but that's not what Professor Dawal said. He said, he did not say, as the defence suggested he did, that the majority of the Janjaweed in Wadi Salah came from Salamat tribe. That's what the defence say in paragraph 336. Again, in fact, when it was put to the joint expert that the Salamat were significantly represented, not the majority tribe, significantly represented, he said, "I've heard it reported so." This isn't evidence, Your Honours, that the Salamat were the majority or the predominant tribe in the Janjaweed. And the joint expert also went on to say that he had not studied the organisation of the Salamat militia or the response of the Salamat tribal leadership to calls for mobilisation. And to close this point, Your Honours, On the slide before you, the slide with Abd-Al-Rahman as Agid al-Ogada and the Agids below him as the senior militia leader, you'll see that we have plotted the evidence from the various witnesses about the tribes of the Agids subordinated to the accused. And you see that those tribes are Rizagat, Beni Halba, Misriya, Taisha, Tama, Mahariya, again Rizagat, and again Misriya. And your honours will have noted that one tribe in particular is missing, the Salamat tribe. To close this point, your honours, and I'm conscious of the time, contrary to the defence brief, paragraphs 338 and 339, the evidence overwhelmingly demonstrates that Abd-Al-Rahman was at the top of the Agids in the Wadi Salah and Mukjar localities, and regardless of whether those Agids who were subordinated to him were called Agids or Agid al-Ogadas by some witnesses, the evidence demonstrates that whenever he was on the ground, he was the senior, the foremost militia Janjaweed leader. And that evidence, your honours, is set out in paragraphs 128 to paragraphs 148. And I'll conclude. This is a good time to break, your honours. Thank you.
Sorry. Mr. Chairman, I was just wondering, so you've got about another half hour after lunch, is that right, on your own? You said you were going to be an hour and a quarter, and you've had 3 quarters. I mean, I'm not holding you to that. I'm just trying to work out.
No, that's, yeah.
Yeah.
That's, if I've had 45 minutes, then I've got 30 minutes more.
Yeah, right. And then, as I understand it, Ms. Whitford's going to be addressing us.
Ms. Morris will follow me.
Ms. Morris.
Miss Whitford.
Right. So you're going to take the rest of the afternoon?
Yes.
Yeah. All right. Thank you. We'll adjourn until, I think we'll say 2:15. Rather, we'll just knock 15 minutes off the normal hour and a half. Thank you.
All rise. We will.